Welcome to the Neighborhood Law Center. I'm your host, Melvin Burris, and today's topic is eminent domain, the taking of your property. What are we going to do about it? And to answer that question, we have two guests. One is Deputy Mayor Don Bennett of the City of Peekskill. Welcome, Don, Mayor. And the other is attorney, I'm sorry, Attorney Mark Weingarten. I'm giving you a title already.
Well, he was the chairman for some time, so that's okay.
Okay, so I'm still in politics. Attorney at law, welcome,
Thanks
Mark.
for having me on, Mel.
Okay. Before we get started, would you like to give a background to the audience and tell them a little bit about yourself?
Well, why don't we give our guest to Peekskill the first shot at it?
Okay, thank you. I don't live that far away. I'm from Lewisboro, so it's we are up here from time to time. But I'm an attorney in White Plains. I'm a partner in the firm of Del Bello, Donnell, and Weingarten, Wise, and Wiedeker. I concentrate my practice in representing real estate developers and have been involved in some of the major developments in this area of the state, which have utilized eminent domain as a required tool to bring about those projects.
And currently I sit as the deputy mayor for the city of Peekskill, with having been re-elected back in November for another 4-year term, but now serve at the pleasure of Mayor Foster as her deputy for the next 2 years.
Okay, well, let's get on with the program. One thing is the Supreme Court, in a case out of New London, Connecticut, which you're familiar with, gave local governments broad rein to take private property for economic development, ruling that transferring land to private investors for projects promising to bring jobs or commerce was a public use akin to building a park or paving a road. So first of all, why don't you give us a definition of eminent domain and what its use and purposes are for?
Eminent domain is a power that is vested in municipalities and certain municipal agencies in which they are permitted to take private property for public purpose. The case that you refer to in Connecticut, the Kelo case, is one in which the big controversy that's out there today is not whether or not to use it for a traditional public purpose. We all know that if you have to create a highway or a railroad or a police station or a city hall, that most people understand that eminent domain sometimes must be used. The issue that's out there for the public now to decide is, what about these traditional, more private uses such as economic development, creation of jobs, and taxes? Are those things that should be permitted to be used for eminent domain? And the Supreme Court stated in the Kelo case that yes, it is something, if the local government decides that that's the way it should be, that they have the right to do that. And that's the controversy.
Okay, so did that change any existing law as far as eminent domain was concerned, or?
Well, for the state of New York, the way I understand it, that the legislators have kind of adjusted some of it, because here in the city of Peekskill, we right now are saying that we will not use eminent domain to take a piece of property for private development, which means that a particular individual or corporation would get that property and then make a profit off of it. However, on the other hand, even here in Peekskill right now, with the State Department of Transportation coming in to reconfigure Route 9, we do have a couple of businesses that will be impacted. They have been working with private owners of property underneath the Route 9 bridge to access that property because they will need it. Now, and in this case, though, it was something that was done very cordially. And the state did not come in and say, we're taking it, and not offer compensation. So there are ways to do it. Okay. And the question becomes, who benefits? And the thing is, for the public good, if a municipality, as Mark has stated, needs something for a police station or a firehouse, or if it's part of a parcel that is in the middle of something that could become a public park, there should be a means for the municipality to be able to achieve that property.
Okay. Now, let's go back and say, which government agents can use eminent domain, and which ones can, or is all government or public agencies?
No, so only certain government
Okay,
agencies. Traditionally, it's used by the municipality itself. In Peekskill, it would be the city. There are some traditional agencies also that will utilize it, such as an urban renewal agency will utilize it. Most of the city of White Plains was built on urban renewal back in the 1960s in the federal government and their programs. Also, the industrial development agencies that the state has created and the county has one. I believe Peekskill has an
Peekskill has
IDA.
one, yeah.
They also have eminent domain powers that can be utilized under the state laws.
Okay. Now, what are the basic rights of a property owner if a public agency wants to take their land?
Well, the main right is just compensation.
Okay.
I think everybody has to say that right off the bat. You cannot take someone's property without giving just compensation. We can have a lot of debate and discussion. I can go through what the procedure is, but at the bottom line is they have to pay you. If they're going to take your property, they have to pay you.
Well, how do you evaluate what is just compensation? And the other side of it, I guess, is what if I don't want to sell my property?
Well,
I want to keep my property.
Well, what is just compensation? Is in the sense that, and I will relate to a piece that we had recently with a developer, looking at some parcels along the east side of Railroad Avenue along South Street. Some of those pieces of property were taken, and apparently the people were happy with the compensation given by the developer, but there were two families that said, no, we have bought this property 20 years ago as an investment for our family's future, and we're not selling at all. And so therefore, you have to look at what would be just compensation. Now here was the family bought this property because it's rental property, multi-units in it, and they were hoping that their family would be able to live off of it going forward from there.
Okay.
So how do you justify being able to take a piece of
Well,
property?
we're looking at, are you looking at market values? Are you doing
Right.
appraisals? Or how do you come to
The private
a reasonable
negotiations, which the deputy mayor points out, are subject to anything that the buyer and the seller and the potential purchaser and who's normally the developer and the purchaser would go. The way the law works is if there's a dispute and it goes to court, the first thing that happens is there's a requirement that the municipal agency has to get an appraisal by a licensed appraiser, and they come up with a number. The other person goes out normally and gets their own appraisal because you're in a court proceeding. Typically, the municipal appraisal winds up lower than the seller's appraisal, and then there's a discussion over that. If they cannot come to an agreement at that point in the process, but interestingly enough, before the property is, before we get even too far down the road, an advance payment has to be made. If the condemnation is decided to go forward, they must pay them the money which they are allowed to accept and still continue to fight for what they call additional compensation. Go to court and say, they didn't give me enough. So if you put the property at $100,000, they have to, the appraisal of the municipality, they must pay the $100,000, and then they can go to court and say, no, not enough, you owe me an additional $50,000, $70,000, $80,000, and there's a 9% interest rate that runs on that money if they're successful in proving in court that that's what the landowner should get. In addition, if there are tenants involved, the tenants also are entitled to just compensation. So in the instance where there's a landlord, which we just described, if there's a tenant inside the building and they have fixtures in the building, for example, you have a restaurant, you have to be paid for all of your equipment, you have to be paid for your tables, your chair, all of the fixtures that are in there, you're going to be compensated for that if you have to move your business. And there are other compensatory items for residential and commercial having to do with moving expenses and things of that nature.
We get to the point where how does the property owner knows that the public agency will be taking their property?
From what I understand, a notice should be sent to the property owner in question, and I think it's like 90 days.
It's actually, in some instances it's 30. There's different notices that get sent because there's different parts of the procedure. First you're notified that they're thinking of taking your property, and then there's a public hearing on that. Then there's talk about the public purpose of it and things. There's different. Then if it happens, you get a notice of an appeal. But I think what's important about this question is to understand that one of the projects that I worked on in Portchester was one of the changes that was created in state law. For decades, almost a century, the New York state law said you publish a notice in a newspaper. Some people might not ever see the notice in a newspaper in those little, advertisements in the classifieds that you see. But out of the Portchester case, they said, you know, this really isn't fair that somebody didn't get that notice. The New York State government, based on that, changed the law, and the law now requires a direct notice to go to the landlord to tell them that we are taking your property.
And
That's a
how
good
long,
change in law.
and how long does the homeowner has, or property owner has, the time between that to appeal it or to
Well, the
bring
thing is,
counteraction?
the municipality has to have a public hearing
Right.
in order for the rest of the public to come and voice their opinions also. I mean, the thing is this, if it's something for the public good, like a park or a police station or a firehouse, they should also be made aware of the fact that the municipality in question wants and needs that property. So then the public comes and says, well, you know something, maybe we don't need to have that firehouse and that particular piece of property. And then maybe the municipality will then go back to the drawing board and look somewhere else. But on the other hand, if it's part of what, let's say it's the greenway along the riverfront green, and that house sits right in the middle of what would become the walkway, and we need it in order to complete something that the state is asking us to do, then we have to do it.
Okay, so now we get to the point where traditionally eminent domain was the taking of a property for a public benefit or use. Now we've extended that for the taking of a property for economic development, or
Well, the Supreme Court said that.
Well, actually, to be frank, that was always the state of the law. It hasn't changed. It was challenged, and the Supreme Court said, yes, you can continue to do it this way. It's the way it has always been. It did not change. The law was not changed. What happened was the court finally went up to the Supreme Court, who finally decided to take on this matter and decided at that point that it still has to be for a public use. The determination in Keeler was that the creation of economic development, new jobs, increased taxes, the removal of blight, which is also under New York State law as a public use, that those are things that do constitute public purpose. So the general question is, and I know there are people who on the individual rights side that take the position that say we should not utilize this tool. That's on the one hand. There are other people who suggest that if a locality decides that we want to remove uses from our waterfront, for example, there was an example of a case down in Tarrytown where there was an asphalt plant. The people didn't want the asphalt plant, which was an old traditional use from 100 years ago that you would put on the water. They wanted the waterfront open to everyone for access, for park use, for all of these things. You can use it for that purpose, but the problem is, if you're going to spend millions of dollars to remove an asphalt plant from the Hudson River so people would have a view there, how do you pay for it? And most people aren't going to want to spend the millions of dollars to pay for it. So what they wind up doing is make it part of a larger development where a private developer can come in, do something that has an economic return to the private developer, which helps pay for the removal of this noxious use from there, and that amenity of access to the waterfront can be utilized. Now, it shouldn't be used all the time, and some communities may want it, and some communities may not want it. My only issue with it is it should be a tool that the local government, as the deputy mayor said, should make a choice. Do we want to do it, or do we not want to do it? That's it.
you mentioned earlier that the word blight is part of the definition in New York's definition of procedure for eminent domain. Could you expound on that part?
Right.
For us?
Blight is a term of art that's utilized in the statute, and essentially it's a deteriorating condition, which people could use all sorts of terms to it, and it's kind of like you know it when you see it kind of a thing. But essentially it was used, as I said, in White Plains and all sorts of places in New York where you have a downtrodden area where the public infrastructure has disintegrated, where you don't have all of the proper tools. And, you know, for example, in Portchester, one of our big projects, we had I think it was a 34-room, single-room occupancy hotel with homeless people and drug denizens living in it, smack in the middle of Main Street in Portchester. And the only way to remove that and do what they did down there was through the use of eminent domain. Eventually, by the way, there was a private negotiation between the property owner who knew it was coming and the private developer to get that out of there. But those are the kinds of things that eminent domain, and now standing in its place is a movie theater, is a Costco. In the Portchester, as an example, over 1,000 jobs were created. millions of dollars a year in taxes for the community, sales taxes, et cetera, in this 26-acre area that was, you know, the very traditional term blighted is an understatement of what that place looked like.
But on the other hand, we've had a situation just here recently over the last 2 years in Peekskill where the municipality decided to do a blight study, which actually was a misnomer because of the fact that really what it should have been, should have been called an economic study, because most of these buildings were not blighted. We're talking about buildings and properties that were still thriving as best as they could in the economic conditions that the city had, but someone decided to name it blight, and that was not the way to do it, because what some of us on the council said to the consultant and the architect, look, go and talk to the property owner, because half of those people were actually running their businesses in their property. Some were renting or leasing out to others, and ask them, what are their plans? You know, the city wants to do something here in this 4-square block area. Do you want to come along with the city? The consultant didn't do that. Fortunately, though, the architect did. So half of the buildings that the consultant had put down as blighted came off the list.
I have to tell you, what the deputy mayor is saying, I have absolutely no issue with what he's saying. And what it really comes down to, eminent domain should absolutely be the last resort. It should be the last tool that's used to change something around that needs to be changed. There are many things that you can do in advance of that, as one that was just described. And it should be a tool of the local government and their decision to make. But there are going to be instances and times. One of the issues, for example, and one of the problems is if you really want to turn around a 4-square block area or an 8-square block area, it's difficult. You're not going to get, I'll give you an example. You want to have a movie theater in a downtown because it creates nighttime activity, it creates people, it gives off a sense of security, it brings people in. And that's going to bring other businesses in, and it's going to do things to create the kind of community that you want to have. In order to do that, you have to get a lot of land. If you got a lot of individual small lots next to each other, one person says no, and you can't do it. The question is there enough benefit by doing it where you might say, well, there's 38 parcels. That's what we had in Porches. There were 38 parcels of property. And there were 3 people, 3 parcels holding out. What do we do? And by the way, they were all commercial parcels. They were not, no homes.
No
the 100
residential.
people, the residential people that were done, they were moved out. We had people who spoke Spanish, who spoke English. They were relocated. They were paid, actually, our person paid a 300% bonus on what they were required to pay under state law as a payment to get them to move, because we didn't want arguments. We didn't want fights, and it was in our interest to do it. And frankly, there are things in the state law that should be included. I'm one who believes, and I've told this to the assembly people, that they should change it. When it comes to a house, they should pay 125% of the fair market value to go ahead and give somebody and say, we're moving you from your home. We don't want to do it. It's our last choice. We have to do it. But if we do, you're going to benefit by it. We're not just going to give you your just compensation. We're going to give you better than that. And if the economics of the project don't support that, don't do the project. That's just one of my suggestions.
Well, one thing that should not part of the procedure be a study as far as the blighted area is concerned, to see if in fact that this is a viable and economic development type
required
thing?
by law.
Okay.
It's required by law in New York State. It was not required, interestingly enough, in Connecticut in the Kelo case. They did not have to do that. In Connecticut, you can do it purely for economic development. In New York, if you're going to do it for that stated purpose, as a public purpose, you do need a blight study.
You need a blight study, which
blight.
would you say should be economic
Well,
development
no,
study?
it depends on the situation, because in some urban settings, the properties are blighted because they're not used. I mean, they're structures that are uninhabitable, that they're falling down. They're a nuisance, a public nuisance to the city. They're a hazard to the health and well-being of the citizens. So, question, that's blighted. However, when you have buildings that are occupied, the businesses are open every day of the week, 2 of the structures are actually functioning services, health services. How can you say that property is blighted?
Well, what the deputy mayor points out, which is an excellent point, is that you could change the definition of blight under New York state law. Not stop eminent domain, but you can take some of the things that you just said, work it into the definition and say, what you're arguing with is you got a blight study, and you're arguing with the conclusion. And if the conclusion is it was blighted and you don't think it is, part of that may be is that the definition isn't very good, and the definition can be changed, and that's something our lawmakers can do.
And also, the thing is, though, when a municipality announces that it's doing a blight study, and you have people on the outside looking in wanting to come in and do business, they may say, well, wait a minute, they're talking about a blight study? I'm going to go somewhere else. So you lose an opportunity to bring another person in, another business in to do something with a structure that probably wasn't blighted. It just happens to fall into that category because of someone's terminology.
I agree. I'm not as familiar with Peekskill as you are, but my experience is when eminent domain has been utilized in the places where I've been involved with it, these are places that have been blighted for more than 10 or 20 years.
No, no question.
And that's the issue. I mean, it's not that they're going into, but these are long-standing problems. They've tried to do many things. There are many state programs that have been utilized and all sorts of grant programs, and they're just not working. And again, this is nobody. At the end of the day, the people voting to do this, the mayors, the people on the council, they're the ones who are responsible to the voters. And if they're going to do something that's the wrong idea, they're getting thrown out. So it's going to have to be a popular idea, or it's not going to work.
One thing is the deputy mayor brought out is that the municipalities or public agency can profit off of this. How do a public agency profit off of taking a property?
Well, again, if you're talking about a public agency like an IDA, they do get a fee, a development fee, not associated with the condemnation. They don't get anything for the condemnation. But if there's bonding or if they're utilizing their benefits, there is an application fee and there's a percentage of the deal that they get, and there is some money that's generated by that, whether it's for them. The municipality, it's much more tangible. It's your property tax change. You're changing your property tax. Typically, if you're doing an IDA deal, there's a payment in lieu of tax. And in these types of matters, if you're utilizing eminent domain, it can even be above the fair market value of it. An interesting question that grows out of this, not to bore you with Portchester, but being the interesting piece, comparing it to Peekskill, the biggest problem they had down there was such a wonderful generator of money, was because they were a village rather than a city. They got no portion of the sales tax. We built 500,000 square feet of retail. All that money got generated. And unfortunately, it all goes into the state coffers and then goes to all of the different villages around the state.
So
where if you did it in Peekskill gets a piece of that
and
sales
the county
tax.
got its share and never kicked in.
No, but the county, the way we got it done, in that instance, the county put $10 million into the project because they knew their sales tax was coming out. And they actually, it was very interesting. They did what was called really a TIF. They said, we know how much sales tax we get on these properties right now. When you guys open, come up to that amount. You get the next 10 million over the next 10 years, and we'll take everything after that. And the county made a lot of money on that project.
Okay, let me ask you this question though. If a property owner is getting a notice of a public agency and saying we want your property, what would you advise him to do?
Like I always do, call a lawyer. But in all seriousness, they need to, having legal representation is important. If you're a property owner, it's important to protect your rights. And the first thing really to do is to go down to the municipality, call the mayor, call your representative and say, what's going on over here? I want to understand it before I have 30 days to respond, or there's going to be a hearing. Before you even get to that hearing, call over there, call the attorney for the city or the municipality, say, what's happening, why are you doing this? And very quickly, they're going to be obligated to point you to what your rights are.
And more than likely, the municipality, if it's on its game, will have the plan already laid out as to what the dream or the process might be for those parcels, because they should not go into it blind saying, we're going to take this, then come up with the game plan. They should already tell the public at a public hearing, this is the reason why we're doing this. Either the firehouse or the public park, or in the case of the state DOT, the Department of Transportation coming in to reconfigure a road.
Okay.
So the game plan should be already laid out before they send out the notice.
Okay, look like we're running out of time here. As a wrap up, Counselor, would you want to summarize or give some advice back to our audience on this subject here?
Well, again, depending on who the audience is, I'm a person who really believes. I know the problem that happens with eminent domain and anything else is that abuses can occur with any kind of law, and then people get very concerned. They concentrate on one bad thing that happened in Ohio or in a particular place and say, we should never allow this anywhere. I think this is something that works. I think the law can be tightened up and changed and made better, but I think places like Peekskill don't want to give up their rights to do this when they need to do it.
Yeah. Well, and the thing is, we don't want to give up the right. We still possibly somewhere in the future might need to do eminent domain on a small piece of property for the public good. But on the other hand, right now, the city council says that we're not going to use it for private benefit. In other words, we're not going to lay out a piece of paper saying eminent domain and then hand that property off to a private developer who's going to benefit solely on their own. And that's how we like to see it right now.
Right.
Okay. You want to sum up to leave something with the audience, or was that?
Well, you know, the other thing is this. Ever since I campaigned to be elected to the city council 5 years ago now, I've always said we want the people to be a part of the process. And even though with the technology that we have, that people can sit at home and watch our meetings after the fact, it doesn't help after we've already done the business. We'd like for you to be a part of the process. Come to our work sessions, which are on the first and third Mondays. The public meetings on the second and fourth Mondays, we've already done the business. The work sessions is where we do the work. That's where we hold the discussions. You may not be able to say anything directly if you're not on the agenda. However, you could always hand over a note or talk to, you know, ask us to leave the room for a few seconds. But the first and third Mondays, the work sessions, is best for people to be there.
Okay. Well, I want to thank you for coming.
My pleasure.
This has been the Neighborhood Law Center. I've been your host, Melvin Burris, and we've been talking about eminent domain. And our guests have been Councilor Mark Weingarten and also Deputy Mayor Don Bennett. And so next week, peace and God bless.